Now, so far, we've answered two of the questions that we set out to answer. The first was that we sought a very basic definition of consideration. And that definition is that consideration is something of value in the eyes of the law. We then moved on to ask, how do you measure it? And we found that consideration is good so long as it's measurable as an economic value. In other words, it must be measurable in monetary terms. You must be able to assign some form of economic value to it. And that excludes things, of course, such as love and affection. However, it does not exclude, as we saw, things such as a chocolate wrapper, which to most people is worth nothing, but as was found in Chappell and Nestle, it does have an economic value, as does a peppercorn, as we saw from the obiter in that case. So we know now that it is measurable as an economic value. But the third question that we move on to now is, how much do I have to give in return for a promise? What's sufficient? What's adequate? And the simple answer is that the courts don't care. Consideration need not be adequate. Technically, you can buy a car for 1 cent, even if the car is worth a lot more. If those are the terms that the parties agreed on, then so be it. Here's how Hagen Brooks put it. Both being free and able to judge for themselves, how can the defendant be justified in breaking his promise by discovering afterwards that the thing in consideration of which he gave it did not possess that value which he supposed to belong to it? So it's no good agreeing to terms, forming a contract, and arguing later that somehow the consideration is not sufficient. You should have thought about that from the outset. So the courts will not inquire into whether the consideration is adequate or sufficient, but merely whether there is consideration. Recall as well the case of Thomas and Thomas that we discussed earlier. This was the case of the widow whose husband had left some property, and the property was held by the executors of his will. Now, the executors of his will had signed a deal with Mrs. Thomas by which she was able to take the property on lease for £1 a year. They later did not want to honor the agreement because they said that £1 was not sufficient. And of course, if you measured it in terms of fair market value, it wasn't sufficient, but that's not the point. The point is that that was the agreement between the executor and Mrs. Thomas, and so the executor was held to that agreement. So let's summarize. Courts will not question the comparative value of the consideration provided. They will not engage in any form of price estimation. And of course that makes perfect sense. If they did, potentially all contracts would be subject to review. Any contracting party that wasn't happy with the consideration provided because somehow it turns out that they felt it wasn't enough, or they felt they didn't like it, or it wasn't useful to them, might go to the court and ask for those contracts to be nullified on the basis of the consideration being inadequate. So no, that cannot happen. That doesn't happen. The courts do not engage in such price estimation. So for the courts, it doesn't matter how much the consideration is that was provided. In other words, whether it's sufficient or not. All that matters is that it is economically measurable, as we discussed previously. However, there's an exception to this rule regarding adequacy, regarding sufficiency, and that is where a litigant seeks equitable remedies. So normally the remedies that a litigant would seek, a contracting party would seek, would be damages. But where the remedies sought are equitable, that person would have to prove that the consideration that they provided was indeed sufficient. And that is because of the equitable maxim that equity will not aid a volunteer. But that's a very specialized set of rules. The main rule, once again, is that whatever the consideration that you provide, so long as it is measurable in an economic sense and a monetary sense, the courts will not investigate whether it was adequate. Now that we know what consideration is, that it must be measurable in monetary terms, as well as the fact that it need not be adequate, we can move on and discuss some specialized rules in respect of consideration. The first rule that we discuss is the rule on past consideration. Now, generally, past consideration cannot be good consideration. And we have the case of McArdle to illustrate this. In McArdle, a lady, Marjorie McArdle, had done some repairs and some remodeling to a bungalow which belonged to some relatives. Now, this was done voluntarily. After she'd done the work, the relatives thought it was wonderful and offered her money for the work she had done. And she agreed. So it seemed as if they had formed a contract at that point in time. But of course the problem is that the consideration, namely the work done, was already in the past, had already been done by the time that the contract was agreed. So when the relatives changed their mind and didn't pay her, she sued. But she was not successful because the court said that the consideration was past consideration, and the general rule is that past consideration cannot be good consideration. However, sometimes, in exceptional circumstances, past consideration can be, in fact, good consideration. Now, there's a three-stage test which is formulated in the case of Pao On and Lau Yiu Long, a Privy Council case. And if we can satisfy that three-stage test, then indeed past consideration is good consideration. Now, before we get to the details of that test, let's briefly talk about the facts of Pao On and Lau Yiu Long. In this case, Lau Yiu Long bought a building from Pao On, but instead of paying in cash, Lau Yiu Long paid in shares. Now, as is usual, or at least not unusual in these circumstances, Pao On agreed not to sell those shares for the period of 1 year. And that is basically to avoid a price shock. If you sell shares all in one go, the price may go down. Now, there was also an agreement that Lau Yiu Long would buy back the shares, or 60% of them, after 1 year at the price of $2.50. That, in a way, made it very safe for Pao On, knowing that he would receive, or they would receive, a certain amount of money after 1 year, no matter what. But what they hadn't thought of is what happens if the price goes up. They may then not be able to profit from the shares going up. So what they did is they went back to Lau Yiu Long, and there was a second agreement. And the second agreement basically indemnified Pao On in case the shares went below $2.50. Now, as it happened, the shares did go below $2.50. But Lau Yiu Long argued that they would not indemnify Pao On because that second agreement was not supported by consideration, because in fact the consideration was in the past. So let's see what the court had to say. An act done before the giving of a promise to make a payment or to confer some other benefit can sometimes be consideration for the promise. The act must have been done at the promiser's request. The parties must have understood that the act was to be remunerated either by a payment or the conferment of some other benefit, and payment or the conferment of a benefit must have been legally enforceable had it been promised in advance. So that was, of course, the three-part test. And now let's break it down. The first part is that the work or service was rendered at the request of the promisor. The second part is that understanding that work or the service would be paid for. And thirdly, the contract would have been enforceable had payment been agreed earlier. Now, if we think back of Marjorie McArdle in McArdle, recall this is the lady who had done some work on the bungalow of some relatives, and she did that voluntarily, and the relatives later on promised to pay her, but after she had done the work. And so that promise to pay her was not enforceable because the consideration was past. Now, what would have had to have happened for Marjorie McArdle to have been entitled to that payment? Well, first of all, when we look at the first part of the test here, the work was rendered at the request of the promisor. That means that the relatives would have had to have been the ones who had asked Marjorie McArdle to do the work. And of course, that may or may not have been the case, but from the facts it would seem that she did the work voluntarily and she wasn't asked to do it. Secondly, even if she'd been asked to do the work by the relatives, there must have been an understanding that that work would be paid for. And that certainly was not the case in McArdle. Any understanding regarding payment or any promise regarding payment was only made after the work was completed. And so, in Marjorie McArdle's case, she probably fails on both those limbs and certainly on the second limb. And thirdly, the contract would have been enforceable had payment been agreed earlier. Well, that's really a moot point here because payment had not been agreed earlier. So the rationale in Pao On Lau Yiu Long is that the amount of payment is fixed after the work is done. So when we call this an exception to the rule on past consideration, it may not be strictly speaking an exception. And that's basically because you are still promising to pay. It's just that you haven't determined what that payment is at the time of forming your contract. It's still understood, the parties are still in agreement that payment would be forthcoming. It's just that the amount hasn't been fixed, perhaps the timing hasn't been fixed, but the basic notion that there was going to be payment, that was understood by both parties at the outset. So I guess for that reason you could say that it's not a real exception in the strict sense of the word. Now let's look at two more cases regarding this. First is the case of Casey's patents. This case, in a nutshell, involved three parties. On the one side there were two inventors, and on the other side there was a manager. Now the manager helped the inventors with their patents, and this process went on for a while. Eventually the patent was registered and the inventors transferred a share of it to the manager, basically as a way of saying thank you for the work that he had put in. They then changed their minds and wanted the share back, saying that he had not provided consideration. And of course, on the facts of it, whatever consideration he provided by helping them would have been in the past. Now, although the judges in Casey's patents do not spell out the test in the same way that it was spelled out in Pao On Lau Yiu Long, the rationale is very much the same. Namely, that although it was not clear what amount might accrue to the manager, there was an understanding from the outset that his work would in some form be remunerated later. And again, this is exactly what happened, which is why the manager was entitled in the end to those shares. Now, in Roscola and Thomas, Mr. Roscola bought a horse from Mr. Thomas, and that contract was formed and payment was made. Now, after the contract was formed for the sale of the horse, Mr. Roscola asked Mr. Thomas about the condition of the horse, and he was told that it was in good condition. Now, it turned out that that was not true. It was not in good condition at all. So, Mr. Roscola sued for breach of contract. However, the court held that the promise made by Mr. Thomas that the horse was in good condition was not supported by consideration, because the consideration in this case was past consideration. The money for the horse had already been paid. The first contract, the one for the sale of the horse, had already been formed. And therefore, the second contract, namely the promise that the horse was in good condition, was not supported by consideration. The only consideration that we can find was past, and of course, as a general rule, that's not good enough.